Hello everybody, I'm Kerry Shepherd and today I'm going to talk you through the means assessment process for controlled work. This covers the assessment of capital and income, and I'm also going to walk you through completion of the CW1 form. So, looking at means assessment. The means assessment requirements are set out in the Civil Legal Aid Financial Resource and Payment for Services regulations. Now, the application process depends on the level of help that your application covers, and the rules differ for controlled and licensed work. Now, guidance for undertaking the means test for controlled work is in the Guide to Determining Financial Eligibility for Controlled Work and Family Mediation, and I definitely recommend that you have a look at this. There are a number of really helpful links on slide 28 of your slide pack, so definitely do use that and have a look at the information that's on there. So when we talk about means assessment, we're looking at means assessment over a particular period of time. And for controlled work, the period of eligibility is the calendar month up to and including the date of the application. So if you're making your application on the 8th of December, the period of eligibility that you're needing to cover will run from the 9th of November to the 8th of December inclusive. And any evidence of means or income needs to cover this full period, and you need to consider all sources of income that are either received or are due to be received during that period. It's worth noting that although the eligibility periods are the same for controlled work and licensed work, the actual means evidence that you need to have is different. What we're going to focus on here is controlled work. So moving on to assessing means, whose means do you need to be assessing? Well, those of your client. If your client has a partner, you'll also need to assess the means of the client's partner. Now that's someone that they're married to or in a civil partnership with, so it's someone they live with as a couple, and that includes a person of the same sex. It also includes situations where your client might be living away from their partner because of illness, imprisonment, or working away, or the partner could be living abroad, but the relationship is ongoing. I guess particularly in the case of immigration matters, you might need to consider whether the income of the partner and the assets left behind are currently truly disposable or available to the client. The other group that you might need to consider looking at this, the means of, is where your client is a child applicant, you need to be assessing the means of the person who's maintaining them. That's unless they're being looked after by the local authority. Now, when it comes to assessing capital, you need to assess capital in all circumstances, even if your client is in receipt of a passporting benefit for income purposes. That changed in 2013 when LASPO was introduced. The only exception to this is where your client's in receipt of Section 4 or Section 95 NAS payments, and that's in the immigration category of work. Aware where the capital details are not fully completed on your application form, it can result in the application either being rejected in the case of certificated work or the claim being made void in terms of controlled work. So make sure everything's fully completed. You also need to make sure that capital is evidenced as appropriate. Now, as we go through the capital assessment, we'll ask you to give us details about the subject matter of the dispute. So that's assets that are claimed by the opponent. There are a range of disregards that you can apply in terms of the client's capital. So there's the mortgage disregard, which is the value of the outstanding mortgage. And that is disregarded up to a limit of £100,000. There's also an equity disregard that relates to the main home that the client's living in. That again is up to £100,000. There's a third disregard that you might come across, a pensioner disregard. That's where the client or their partner is aged 60 or over and they have a disposable income of £315 per month or less. The allowances that you can apply are on a sliding scale and they're set out in the guidance that's on the link on page 28. Now, there are upper capital limits. So for all categories excluding controlled legal representation for immigration, that limit is £8,000. So if the client has capital above that limit, then they don't qualify. And for CLR, controlled legal representation for immigration, that upper capital limit is £3,000. So again, if the client has capital more than £3,000, then they aren't eligible. I guess just to remind you, crossing through on the form's not enough. You must complete the figures, use a 0 or a nil so that we can see that you've gone through this with the client and that the client is declaring a 0 figure for each of those questions. So looking at income and passported benefits. Now, your client will be passported for income purposes, both for controlled work and certificated work, if they are directly or indirectly in receipt of one of 5 benefits. So that's income support, income-based job seekers allowance, income-based employment support allowance, guarantee state pension credit, or universal credits. Now, to qualify as receiving a passported benefit, that benefit's got to be currently in payment to the client. It's not enough to say that a passported benefit's been applied for or that the client's awaiting a decision. If it's not actually in payment, then you need to be having a conversation with the client to work out how the client's been supporting themselves over that computation period. Now, the client can be indirectly in receipt of a passporting benefit if they're included in the benefits claim of someone else. If they're not actually included in the claim and not named on there, then they aren't passported. It's also worth mentioning that job seekers allowance and employment support allowance have 2 versions. There's an income-based version and a contribution-based version. Now, the client is only passported if they're in receipt of the income-based versions of both. If the client is in receipt of the contribution-based version or you can't tell, then complete a full income assessment looking at the client's income during the computation period. So as I've previously mentioned, where an individual qualifies for a passported benefit, a capital assessment has to be completed, and the only exception to that is for asylum and immigration controlled work matters where the client's in receipt of NAS Section 4 or 95 support. In those cases, the client automatically qualify on capital and income. So how would you evidence a passported benefit? You could have a letter from the DWP. Any letter needs to be dated within 6 months from the date that the application form is being signed. If it's older, you need some additional or alternative information. Now, you could have a bank statement covering the computation period, as long as it confirms that the client's in receipt of the passporting benefit. You quite often see on a bank statement that income support or universal credit is detailed on there, so that would be fine. It wouldn't work for job seekers allowance or ESA because it doesn't confirm whether or not it's the income-based or contribution-based variety, so you'd need additional information there. If the client's not able to produce any evidence of a passported benefit at the initial appointment, then you can always telephone the relevant benefits agency. You'd need to have a note of that call on the file, including the full name, contact number and details of the individual spoken to. There's actually a really handy pro forma for this in the links on page 28. So if you have that information on file, you're not going to be missing anything that we would need to see. And it's also good practice to submit a written request to the relevant agency as soon as possible and follow that up to get it in writing. For NAS payments, where the client's in receipt of Section 4 or 95 support, we'd ask that you obtain written confirmation that's dated within the last 6 months. If the NAS letter is dated outside the last 6 months, then we'd accept post office receipts for NAS payments, provided they can be linked to the client. So they might have a NAS or Home Office reference number or the client's details, and that post office receipt would need to be dated within the computation period as well. So looking at income, how would a client evidence wages and earnings? Well, wages must be evidenced by way of a wage slip, and you also must use the gross figure in calculations. The reason for that is that there may be allowances made on the wage slip that are not allowances under legal aid. Thing to note then is that bank statements aren't sufficient because they include net figures, and as I've just mentioned, there may be allowances in there that we can't include. So for controlled work, you need to provide, the client needs to provide the most recent monthly wage slip from the date on the application form. If the client's paid fortnightly, then we'd need to say the last 2 most recent pay slips, and if they're paid weekly, then we'd need to see the last 4 pay slips. Just as a point of difference for certificated work, if the client's employed and paid weekly or fortnightly, then we're asking to see 6 recent and consecutive wage slips, and if they're paid monthly, then we'd see 3 recent and consecutive wage slips. And for certificated work, if you can't obtain wage slips, then you can complete an L17 form. Now, if your client's a prisoner, we would generally expect you to provide the prisoner income and expenditure statements for the last 3 months as part of the application. There is an exception to this. If the client is single, so he or she has no partner, then the prison income and prison income is the only income and there's no savings, then you wouldn't need to provide a prison statement as well. There might be some situations where the client hasn't received or become entitled to any direct income at all in the previous month. It's quite common in family matrimonial matters. So it might be the case that the client's living separate and apart from their spouse in the main home, and the spouse still meets the outgoings. So you'd need to make that clear on the form. You can also see this in immigration and asylum matters, for example, where the client's recently arrived in the country and hasn't applied for or isn't yet in receipt of NAS, or in family cases where the client's, say, left the family home. So what you often see is that the client's accommodated and supported by family or friends, and in those circumstances you would need to obtain a letter of support from whoever is providing that support to the client. Any letter of support needs to contain the supporter's full details, their name, address, contact number. It needs to be clearly dated. It needs to set out when the support commenced, and if it doesn't cover the full computation period, then you need to make further enquiries to make sure that you have covered the client's income during the full computation period. Any letters need to confirm exactly what they are supporting the client with, and if that includes any element of monies, so things for sundries, incidental expenses, and if there is any financial support, so direct income, then you need to include that as part of your assessment figures on the income part of the form. Again, like the telephone call to benefits agencies, there is a handy pro forma letter included in our guidance. It's in the links on page 28, so it's well worth using that if you are coming across this situation, because you're not going to miss out any of the information we need to see. So where your letter of support doesn't confirm that any monies are being provided to the clients, then we'd suggest that you undertake further inquiries as to how the client's meeting their day-to-day needs and costs. So it might be things like, how have you managed to travel here, if the client has travelled a distance to get to see you to sign up for the application form. There's also the possibility of, if the client has got no evidence and is declaring no income, you might want to consider whether or not this is one of the exemptions that falls under paragraph 3.24 of the standard contract specification. So we'd expect to see that you've considered whether or not that situation is appropriate and you've applied the exemption and the information's been retained on file. I guess the big thing here is that the the assessment of means is a function that's delegated to providers, so you need to be assured that the client is financially eligible for the advice that you're going to provide. So we've covered wages and we've covered letters of support. So how would you then evidence of other incomes that the client might receive? Well, for things like state benefits, including the passport benefits we've already talked about, we generally see the most recent letter from the DWP or Job Centre Plus. That would quite often be the notification or change letter, and the letter would be dated within 6 months of the date of the application. If the letter is more than 6 months old, then we'd expect to see a recent bank statement or building society statement that supports the information that's in that letter. But again, the bank statement needs to detail the benefit that the client's in receipt of. Where the client's in receipt of NAS support, again, we'd expect to see written notification from NAS or the local authority dated within the last 6 months. For working tax and child tax credits, we'd expect to see a copy of the most recent tax credit award notice, from which you can then calculate the monthly payment, or bank statements covering the computation period. We'd also accept those. If the client is in receipt of student grants or loans, then we'd expect to see a letter of confirmation of the grant that sets out the amount of the loan. So you'd then take the annual amount received, divide it by 12 to get the monthly amount. We don't need to see evidence of tuition fees, but we can also see bank statements that show regular loan or grant payments as well. Where there are maintenance payments that are either court-ordered or voluntary, they can be evidenced by a copy of the maintenance order or agreement, cash cheques or bank statements showing regular payments. And for the self-employed, for controlled work, we're looking at the drawings taken within the computation period. So you'd base your calculation on the level of drawings. So if there were no drawings that the client's declaring they've taken in the last month, or they seem really quite low, then you'd look at with the clients the normal monthly drawings that would usually be taken out, and you'd include those in the calculation. If the client's saying that actually we didn't take any drawings out, then you need to establish how they've been meeting their kind of normal day-to-day living costs during the computation period, and you'd look at any income as part of that. The difference with certificated matters, you'd then be looking at trading accounts, HMRC income tax calculations and bank statements, so it's a little bit different there. So we've looked at income. We're now going to look at the deductions that you may apply to the client's income. So, excuse me. The first one is housing costs, so things like rent, mortgage, accommodation fees. They apply in respect to the client's main dwelling only, and the amount has to be net of housing benefit where that's in payment. If the client has no dependents, then the amount that you can apply is capped at £545. If there are arrears and they're actually being paid, then you can consider those as a deduction under the housing costs as well. Now, where the client indicates that they're paying board and lodgings, you may only allow the accommodation costs. So the client would need to provide a letter from the person that they pay the money to, and that letter would outline how the money is apportioned between food, utilities and rent, and then you would work out what the accommodation costs are that you would allow against the client's income. Where the client states that their housing expenditure is more than a third of their gross income, then we'd expect to see extra evidence to support that figure. So that might be something like a bank statement, a mortgage statement, tenancy agreement, rent book, that kind of information. A further allowance that can be made is for dependents. The rates for dependents are on the current key card and in the Lord Chancellor's guidance, and dependents allowances can be made in respect of partners, adult dependents and children. Allowances can also be made in respect of childcare costs. This relates to the actual costs that are incurred because the client is working or studying. It can be things like nursery fees, childminder fees, or a combination of those. It can be deducted for students paying childcare if they're receiving study-related income during the time that they're absent from home because they're studying. There is proof that we need to see further proof if the fees are quite high. So that would be over £600 per month for a full-time equivalent person, and that would be prorated down for part-time employees as well. And we'd expect to see that evidenced by way of, say, bank statements, childcare agreements, or recent receipts. If it's the case that the client pays childcare in cash, then there may be cash withdrawals on bank statements that can be highlighted as well. Maintenance payments that are actually being made can also be allowed for. So that would apply to, say, an ex-partner, a child, or a dependent relative where the recipient doesn't live in the individual's house. Excuse me. The only exception to this is where the individual and their partner are living in separate and apart under the same roof. So perhaps housekeeping is paid out by the individual to meet the partner's needs, and that can be treated as an allowance in the same way as maintenance. Now, a liability to the child maintenance service isn't enough to allow deduction. Payment must actually be made during the computation period, and evidence of the payments could be via bank statements, wage slips that show child maintenance deductions, or recent receipts, and we'd expect to see that on file. I guess the thing to remember here is that more is more when it comes to information. The more information you have on the file or the application form, the easier it is for us and your internal file reviewers to verify the means assessments. So we definitely suggest that you clarify any unexplained transactions on bank statements, that you explain how calculations have been made. So you're showing clear calculations of what's been included when you're assessing eligibility for controlled work matters. You might need to explain why any income, earnings or credits haven't been considered as part of the calculation. And if anything looks or feels wrong, have a more in-depth review of the information that's being provided and put the details on file. Do always refer to the relevant reference materials and guidance, especially the Lord Chancellor's guidance that I keep referring to, and all the key links are on page 28 of the slides. I guess always ensure that the evidence of means is provided and it covers the full computation period. That you need to make sure is on file. If it's one of those rare occasions where actually you were not able to obtain evidence and you're relying on one of the exemptions under the specification, then we'd expect to see notes of what efforts you had made to obtain the evidence and a clear written explanation as to why you've decided to go ahead in the absence of full details being on file. As always, ensure all application forms are fully completed, signed and dated. For controlled work, your claim might be made void if it's not. And for certificated work, please make sure there's no unanswered questions. It could mean that your application is rejected, which takes longer to get a decision for you and your client. So have a quick check before you send it through to us. I guess remember, this is a function that's delegated to you. You need to be assured of the client's eligibility when we're talking about controlled work. So I'm just going to talk you through completion of the Controlled Work 1 form. So this is the application form for legal help, help at court and family help lower. It's also the application form for exceptional case funding. So you can see from the the details at the top here, that you're asked to confirm whether or not this is an application for exceptional case funding. So this covers an application for representation where matters aren't in scope for legal aid funding, but you're allowed to make that application, or the client is allowed to make that application direct to us. So we have the Equal Opportunities Monitoring section on here. Completion of the section is voluntary, but obviously if it is completed, it will be treated in confidence and will be used purely for statistical monitoring and research. But the section that you do need to make sure you complete is the client's details section at the bottom. So full details, as far as you possibly can, need to be completed on the form. Moving on to page 2, you would only complete this section for provider details when you're making an application for an extension of a cost limit. So if it's a straightforward legal help form, you would not need to complete that section. Moving on to page 3, this is a page where we're asking you for some further information in terms of the actual matter that you're advising the client on. So the first question is asking whether or not the client's in receipt of Section 4 or Section 95 asylum support. If the answer is yes, then you're going directly to the evidence section on page 7 because there's no assessment of income or capital. You're asked whether or not the client has a partner whose means are to be aggregated, so you would tell us that under question 2. Give us brief information as to the type of case, so family, housing, immigration, whatever that might be in question 3. In question 4, you're telling us whether or not the case is about ownership or possession of assets and financial provisions. If it is, you complete question 5. If not, you go straight to the Part B capital section. And in question 5, you're telling us whether or not the client's assets have been claimed by the opponent. If the answer is yes, then you're giving us further details of that subject matter of dispute. If it's no, then you're moving on to Part B capital to look at capital. So looking at Part A, this is where you're giving us the details of the subject matter of dispute. So this is any property, assets or possessions that the opponent has made a claim to in the case. So if it relates to property, then we're asking you to give us an estimate of the current market value of the property, along with the details of the outstanding mortgage or secured loan. The client may have more than one property, in which case the main home is detailed on the left and the values relating to the other property are on the right. There may be a valuation that the client already has, or it may be an estimate based on perhaps an internet search, something like Zoopla perhaps. This is the client's declaration, but obviously if it feels wrong to you and you're familiar with that area, then you might want to do a little bit more exploring with the client. Under question 2, you're telling us whether or not this property is held in joint names with the opponent. And then under question 3, you're giving us the proportion of the value of the property that would belong to the client. So moving down a little bit further, you are then under question 4 going to calculate the total net equity that relates to that particular asset. So that would be the current market value minus the mortgage disregard that we've already detailed under question 1, and that would give you the total net equity figure for the main home and the other property. You would then calculate the client's share of the total net equity. So that's the total net equity figure at question 4 multiplied by the client's share of that property, which is detailed at question 3. That would then give you a figure to which you would apply further disregards. So that would be the subject matter of dispute disregard. So up to £100,000, followed by the equity disregard of £100,000 to the main home. So if we were to work on the basis that a property was valued at £150,000 and the mortgage was currently at £75,000, that would give a total equity of £75,000. So if that was owned in the client's sole name, once you'd applied the subject matter of dispute disregard to that figure, that takes that £75,000 down to zero. So that would give the client a net equity of zero in that particular property. And you'd apply that same principle to the main home and to the other properties. There are some calculations and some really good examples within the Lord Chancellor's guidance to determining controlled work. If you are wanting to work through this in more detail. So once you have the equity figures, you are then looking at the other assets and possessions that are claimed by the opponent. So that would be things like savings, investments, any valuable items and any other capital. Once you have those figures for the client and the partner, you would have a total capital for Part A figure here. Moving on to Part B capital, it's very similar to what we've just worked through in terms of Part A. So if the property has been claimed by the opponent, then it would be detailed under Part A capital, so subject matter of dispute. If it hasn't, then it would fall under Part B capital and you'd be working out the same process under Part B. So you would be looking at the current market value, outstanding mortgages or secured loans on main homes and other properties, confirming what the client's share of the property is for assessment, working out the figure for the total net equity and applying the relevant disregards to that to get a client's share of the total net equity. Sorry, it went too far there. Once you've got the final assessed amount of the client's equity, that's the final figure that you're looking at in terms of the client's property. You then look at the savings, investments, valuable items and other capital items for the client and partner, and you would total all of those together to get a total of all capital assets for Part B. If there was a figure for the subject matter of dispute as well, that's where you would put a total of all capital assets for Part A and Part B. If the client has capital assets that exceed £8,000 for all categories except for immigration, then the client's not financially eligible because of capital. If the client has capital of more than £3,000 for immigration controlled legal representation, then they're not eligible. Provided they're under those limits, then the client is eligible. You're then looking at the client's income. So if the client is directly or indirectly in receipt of income support, income-based job seekers allowance, income-based employment and support allowance, guarantee credit or universal credit, then you would go tick yes and go directly to the evidence section on page 7. If the client's not directly or indirectly in receipt of those benefits, or you're not sure if the client's in receipt of the income-related benefits for ESA or JSA, then you'd continue to complete this form. So when you're completing the income details, always use monthly figures. So if paid weekly, multiply by 52 and divide by 12. If the client's paid 4 weekly, multiply by 13 and divide by 12. So you're looking at the income, that is the income that the client's received or was due to receive during that computation period. So the calendar month up to and including the date that the client is signing the form for both the client and, if appropriate, their partner. So we'd expect to see their gross monthly earnings detailed on here, along with any other income. And when I mentioned having a note for the calculations, it's really useful to have that information broken down because it can get quite complicated when you're trying to work out what the client's other income might be. You would then calculate the total gross income for both the client and the partner, and you would ultimately end up with one figure that covers the income for the client and the partner. We're then looking at the allowances that I'd already talked through previously. So the housing costs would be detailed for both the client on the left and the partner, if appropriate, on the right. So that would be the mortgage instalment, which is capped at £545 if the client has no dependents. It would be the rent net of any housing benefit, if that was appropriate as well. It would also be the allowances for accommodation costs if the client was receiving board and lodging from someone that they lived with. You would add in the details for the dependents allowances, that's the partner, and then any children aged 16 or over or aged 15 and under. And again, the allowances are detailed on the most current key card or in the Lord Chancellor's guidance for determining financial eligibility for controlled work and family mediation. From the client's wage slip, you would be able to determine the tax and national insurance figures for both the client and their partner, if that's appropriate. There's also a standard allowance that you can apply of £45 where the client or their partner are working. You would add in the figures for the maintenance payments that we've already discussed. That's payments that are actually being made on the form, and there's also an option to put the details of costs for childcare costs because of work or self-employment. Again, they are limited to £600 for a full-time equivalent and prorated down for part-time employees. There's also the option to add the details of payments for any income contribution orders for criminal legal aid as well. Once you have all of that information, you would total them up and you would get a total monthly disposable income figure for both the client and the partner. Add those up and you have that total monthly disposable income figure for the client and their partner. You would then deduct the allowances from the total gross income. Once you have that final figure, provided that figure is £733 per month or less, the client is financially eligible on the basis of their income. If they're in receipt of a figure greater than £733, they're not eligible. So moving on to the next page, on here you are confirming that you have had evidence given by the client in support of their means, or if there's any further information that needs to be recorded, you can put that on there, or if there's any justification because you're relying on a couple of the other standard specification allowances within the contract, then you would be detailing why that would be appropriate on this form here. The next 4 pages relate to the legal aid privacy notice, which the client needs to be made aware of. So I won't go through those just now. And then you come to a really key page, the client's certification on page 12. The client needs to confirm whether or not they've had previous legal help or family help lower on this certification section. If the client's saying that they have had previous advice, then there are relevant contract terms that relate to this. So the client needs to say when that matter ended, and in terms of a further matter being started, the specification confirms that it needs to be a period of 6 months since that original matter was billed before you can start another legal help matter, or there needs to have been a significant change in circumstances, in which case you'd need to justify that on the file. So the client completes the certification, and at the very bottom of that section, the client has to sign and date the form, as does their partner if they have one. So that must be signed and dated. Without that information, you run the risk of this claim being made void. So on the next page, legal help and help at court, you're telling us other information that relates to the matter. So if you've done something like travelling out to see the client, perhaps because they were unable to get to the office, you'd give us the details here. As I've mentioned, you might have provided legal help to a client who's already received it on the same matter within the last 6 months. You're telling us why here. So any of these reasons, give us some further information so we can see why actually this is a completely justified step on your part. Now, legal aid is only available for proceedings that fall under paragraphs 12 and 13 of Part 1, Schedule 1 of LASPO. But there are some matters that can be brought back into scope as a result of further information being able to be provided. So this predominantly relates to private family law matters, where perhaps it's dealing with family divorce or contact with children matters. In those cases where you have what we're calling gateway evidence to bring those matters back into scope, you would tell us that you have that evidence there on the form, and you must have that evidence at the point that the client signs the application form for the matter to be in scope. In addition, for family help lower private law matters, we're asking you to tell us whether or not the criteria for the merits criteria were met, and whether an application for legal representation was made in the matter as well. So page 14 is a page for usually our admin teams to tot up time spent and costs, detail the disbursements on the case. And where this application is relating to an application for exceptional funding, the certification section needs to be completed by your authorised litigator. The evidence checklist is on page 15, and this is where you would simply detail the information that the client's provided in support of the application, whether that's income or capital or expenditure. And that's it in terms of the walkthrough for the CW1. If you need any further information or have any scenarios that perhaps haven't been covered in the webinar today, your first port of call would definitely be the Lord Chancellor's guidance for determining financial eligibility for controlled work and family mediation. As I've said previously, the links are on page 28 of the slide pack, and I would definitely recommend that you use those. And that's it from me, so thank you very much.